Oh, okay. Looks like we got more people waiting. And there's Linda. Hey, Nicole. Wow. Hi, everybody. Thank you for being here. Did I miss anybody? Waiting room one. What is that? Alice? Alice, welcome. Okay, there we go. Get everybody in here. And so we are working off of a different platform today. I'm hoping you all can hear me. Frankly, uh, this morning was very interesting. So this morning we did a class on how to create the winning listing presentation, and I don't know. I had a ball. That was a lot of fun. But then here we are today, in the after, and we had some internet problems and stuff like that. Plus, what we've done now is we have now I've got an alarm going off. So what we did is we switched from a webinar platform to a meeting platform. So there are going to be some differences. And part of that is just so that you're all aware, I can see you. Hi, Karen. I couldn't see you before because before we did webinars, and I have to admit that it was difficult because a lot of people weren't interacting, and I think part of it might have been the technology. But now it's much better, and I can see you. So before I couldn't see you, now I can see you. So just so everybody knows, if you've got your camera on, then we're going to be saying hi. So anyway, so that's the way that it is. So and I can see that some of us are still hooking up, but let's go ahead. The other thing, and Karen, I need to make a note to tell Corey to fix the admit feature. People need to be able to admit themselves. I mean, because I hate to miss somebody. I think that's and we have such great members here at San Diego that I don't want anybody to be left out. So anyway, we are at the Greater San Diego Association of Realtors, and can everybody hear me? Okay, Karen?
Yep.
Yes. Good. Okay. Thank you. All right. So we are at the Greater San Diego Association of Realtors, and my name is Kevin Burke, and I have that JD after my name, which means that thank you, Jennifer. I can't see if it's Jennifer or not, but the JD, juvenile delinquent, for those of you who don't know what that stands for, and then there's my telephone number, and then there is my email address. So my experience is that a lot of times, like I'm doing things, and so like right now, I have to double check my phone to make sure that I have it on stun or ignore. But listen, I want to talk with you, right? I want to help you. Whatever I can do, please let me know. I'm happy to do that, and I'm saying that outside of my relationship with San Diego. I just want to make sure that you're okay. So my email address is frequently the way that people are able to get a hold of me. That is pretty effective. So and you'll see at the bottom. It should be at the bottom of the screens on most of the thing. Yeah, there it is. Look at that. Okay, so I did it right. So we've got the email address down at the bottom. I'm trying to move that up out of the way. There we go. So on the left-hand side, stuff I've done in the past. I do, I have a broker's license in several states. I actually run brokerages in several states. And I have to tell you that the subject matter today that we're going to be talking about is kind of near and dear to my heart because California's been my home for well over 40 years. 40, oh boy, yeah, more than that. 40 years, and the forms are my tools. They're the things that I use to do my business, and I'm hoping you will as well. So I want to show you a couple of neat little tricks on how to find the forms, so that you're not dependent on some of the stuff that you have to be dependent on. I do continue to teach continuing education for attorneys, MCLE credit, real property law. I got out of teaching 15 years of real estate classes at the colleges because I found I was dealing with people that may end up never getting a license, and so there's another admit. So may never end up getting a license, and I wanted to make sure that I was helping people that actually wanted to do real estate. So that's kind of why we're here today. So screen number 2, I was chair of risk management West Group last year at the National Association of Realtors. Last year I was chair of the Realtor risk management and consumer protection at California Association of Realtors. Next year, I will be chair of Legal Affairs Forum. Right. I called them up and I said, what, did the guy that you guys picked not want to do it or something? Because, somehow I ended up with it. But I'm very happy to do that. I'm very happy to serve. So that's kind of where we are. We're going to be talking about stuff that's going to appear to be legal. I am not a practicing attorney. I want to make that really clear. It doesn't mean I don't want to help, but I do a lot of trial work. Probably, I hate to admit that almost half of my, well, maybe 20% of my time is devoted to getting involved in lawsuits, always somebody else's. My goal is to keep you from having that happen. I don't think there's any need for that at all. And so my standard of care is my specialty. Did the agent do what they were supposed to do? Things like that. Agent's duties of inspection and disclosure, and then finally market conditions in San Diego County. So again, those are my specialties. And I don't want you to have to hire me. That's just how it works, right? Because if you have to hire me, that means something went wrong. And I think from all of my experience, I think sometimes it really just meant that communication broke down and we weren't talking to each other. So conversation is not intended to be a substitute for the advice of your broker, nor for that of your attorney. Please consult with them as appropriate. You're paying them to be there and they want to talk with you. Okay, so make sure you're consulting with your broker about key issues, and hopefully you don't have to have as many conversations with your attorney. So our talk today is intended to be interactive. Please ask questions. And by the way, it's very easy for you to go hot mic. So if you hit the talking, if you start talking, we're all going to hear it. Okay, so please ask questions, offer input. Hot mic, I'm fine with that. We have we don't have an incredibly large group, but but otherwise use the Q&A button. Nobody can see your questions. I can see them. I will probably paraphrase them, repeat them back so that everybody understands what you're asking. There's no such thing as a stupid question, right? Okay, please. It's stupid for not asking it, maybe, but I want you to be comfortable with that. So I do look forward to hearing from you. So this morning we did how to create the winning listing presentation. This afternoon we're going to talk about new and revised forms. Not quite as bad as it was in July, but you'll see there's some good stuff in there. On Thursday morning, we will be doing create the ultimate listing agreement. And then in the afternoon, I will show you how to create a lease, how to create lease transactions, and how to create those amazing lease templates. Okay, so easy cheesy. So if you haven't been helping people find rental housing, this will make it so that it's a lot easier for you to accomplish that objective. And I think that rounds me out for the year, right? I think after that, I'm on vacation or something. I don't know. I'm unemployed after that point, so there's nothing wrong with that. I'm okay that way. And member benefits. So today we're going to talk about the December 2023 new and revised forms. All right, those are the CAR forms. I know that SDAR updated a bunch of their forms. Some of them, like the local area disclosures, were updated on January 1. I'm not on that committee anymore, so I don't know for sure, but I'm pretty positive that when I saw the forms revisions, that's when it was. So make sure you're using your local forms. And then I always like to say, yes, there's a form for that. So the DRE has actually called me a forms expert, which I don't know where I got that from, but I like answering questions about forms. So this is a good time for us all to chat. So let's take a look at a couple things. I want to take a look at the CAR standard forms website, and I got to figure out how to, there we go, location. So let's go to the California Association of Realtors webpage. Here we are at the homepage, and looking at this, and I'm trying to move that screen. There we go. So when I get onto the homepage, and by the way, if you're ever having trouble and you want to figure out how to get back to the homepage, you just click over here where the logo is. That's like hitting the refresh button. That takes you to the homepage. There's Ryan. He's a super guy. So from here, where can I find those standard forms? So I want to show you. I'm going to go up here to Transaction Center. And again, if I'm going too fast or if anybody needs me to slow down, please let me know. Transaction Center. I'm going to go over here to the right-hand side where it says Standard Forms. I'm going to click on Standard Forms. And then from this point here, I get this little window. And right here, I have Forms Revisions and New Form Releases. I'm going to click on that. And then you can see that this is going to load my list of the various forms that are, the various updates that we have done. I'm going to click on the December 2023 And by the way, I went last night. I went into this and downloaded them all again just to make sure that I have the current versions. CAR, the forms they're actually going to release, I'm going to show you. Here's what they have on the calendar. So the first thing we see is the quick summary guide. And if I want to look at that, I'm going to go to a place. Where did I go? Here we are. Here's the summary guide. Now, some of you, and I know Karen's going to notice this, but in the upper left hand over here where it says April 2011 forms release. So again, Karen notices stuff like that. That's kind of a fun thing for me, and that they're still using that same template. But this is it. This is the December 2023 forms release. Going to come out on the 18th, the 19th, thereabouts. But understand that this is not an exhaustive list. They're still working on these. These are still draft. So folks, please do not use the forms we talk about today until they go hot next week, right? So today is the 12th of December. And so roughly in a week from now, and if you're anything like me, I'm on the website. I'm just keep on clicking the button, waiting for the new ones to come out because it's a very exciting moment for me. So whole bunch of stuff in here. The only new form we're going to talk about is going to be the buyer homeowners insurance advisory, which I'm thinking, like, why did it take us so long to do that? It's the same thing as the fair housing, and the square footage advisory forms that we have. It's like, what took us so long? Square footage is still the #1 litigated issue against real estate agents, and it took us until just a couple of years ago before we finally came out with that. Again, as I always say, all of the material that I have prepared here today is fair game. I will email everything to you. I've got it all in one place. Obviously, I'm more than happy to send that. And Alice, I see you here. Alice, I'm going to send you everything from this morning. Okay. I just, there's a little bit of a break that I definitely needed there. But back, I'll send all that to you this evening. And then I don't know where they're putting these recordings. But hopefully I'll be able to load those up onto the YouTube website. Thank you, Alice. That's very kind. So a handful of business forums. But anyway, let's get into this, because this is just the start of what we're going to be doing today. Let me go back over to I'm going to go back over to the Zip Forms program now. And I'm going to go over here to my forms, which of course is going to do crazy stuff again. I mean, for God's sakes, let's do this a little differently. Watch this. I'm going to show you a neat trick. And you need to be doing this, folks. You need to be creating templates. You need to do everything has to be template driven. And there's some reasons for that. And so there's a good time to talk about that. So when CAR updates the forms, okay, very important. When they update the forms, they update them in the library. Okay, and so let's go ahead. I'm going to open up buyer offer template. So you see I have a template for everything. Okay, so because everything we do as a business is by rote. We do the same things again and again and again. And so I never worry about fair housing complaints. I always treat everybody equally. I treat everybody fairly. And this is kind of my way of doing things. And so I create a template. Now, when I've got my template going over here on the right hand side, this is called the forms library. Okay, where it says all forms. So here's what CAR is going to do. I'm going to click on that button so you can all, and there you see I'm looking at San Diego risk management forms. I love San Diego's risk management forms. I'm going to go back over here to California Association of REALTORS. And here are all the forms in the library. So we will update the forms, which means that if there's an older version of a form, we're going to put the newer version in there for you. Okay. And then if there's a form that we didn't have before, we will put that form in there. Okay. And so how do you tell? Well, right here where it says all, can you see this? Okay. I click on all, and then I go down to form update for 6/23. And this tells me all of the forms that were updated in June of 23. So guess what? When we roll into next week, that number will change. Instead of saying 6/23, it will say 12/23, because we're going to update the forms on 12/23. So when you're in the library, you can see what forms have been done there. Is somebody trying to get in? Okay. So you can see all the forms, you've got the whole thing, right there. Okay. All right. So, so that's my forms library. So again, we will update the forms. we will put in new forms. This is the grandbaby of where everything is, okay? All right, so now let's talk about templates for a second. So we're going to update your template. So if you have created a template, and I want to strongly encourage you to do so, when you have a template, we will update the template. So we will put the updated forms into your template. We will not add new forms. Okay, that's all in the library. We will not add a new form in there. So for example, when we changed the BRE to the BRBC, this folder right over here was BRE, and inside of it was the buyer representation agreement. When I clicked on it, it had the BRE. Well, the BRE doesn't exist anymore. So it sucked the BRE out of the template, but did not put back in the BRBC. So those are the things that I'm going to do after the forms release. I will update all of my templates. And again, as I offer, one time, send me an email. I will send you my templates. Okay. All right, so that's where that is. So understand, in your template, we will update the form, so you're always using the current version of the forms. Everybody with me on that? Is that okay? You're always going to be using the new version of the forms. All right. Now, if they add a new form, they won't put it in there. You're going to have to do that manually. But again, my templates will reflect that. Okay. Because frankly, it's easy. This time we've only got one new form, and we'll talk about that in a second. So again, I have my library. I have my template. Let's talk about a transaction you have in progress. So if you have a transaction in progress, they are not going to touch it. All right. Now that's good and it's bad. It's good because they don't want to touch they don't want to mess up something that you've already done. Right. You got something going on. You're using the FERPTA, for example, and the FERPTA is the one that was in use at the time when you started the transaction. You've sent it around. Everybody signed it. And there's a new law out, by the way, that says that the Department of Real Estate says that they're gonna consider the transfer disclosure statement law, for example, to be the law in effect at the time that you created the transaction. So that means that if they update the forms 3 weeks into it, you don't have to update the forms. So just kind of a little aside there. And again, I'll send you my new laws if you want to see that as well. So I don't want to take away Gov's impact that he does. I'm not sure exactly when they're having Gov come out, but he always does a great job. So Monica, okay, Monica's here. Okay, so again, template. We will update the forms that are in your template. We will not add forms. When I get into a real estate transaction, we're not going to touch it. So how is that important? That's important because if you are in the practice of copying transactions, which means, you had a transaction you just loved, it was such a great transaction, and you don't want to, you did such a great job with it, you want to keep using it. Again, we're not going to touch it. So if you continue to use that transaction as a model, then you may be having old forms. You may be using old forms that have not been updated. And remember, the forms are updated. CAR is not going to, in fact, let me show you this again. So when I go down here to the bottom of this, you'll see that CAR's position no longer monitors the legal validity of any prior form version, and the user protection agreement only applies to the most current version of a form. So if you want to have that protection, you need to make sure that you are using the current versions of the forms, okay? So finishing off out here, here's my advice. If you've got a transaction that you just love, then save it as, after you're done with it, of course, save it as a template, and then apply it to new transactions that you create. Don't keep using it because you're going to be keeping on changing your template. So save it as a template. And again, I'll talk about this on Thursday afternoon. I'll spend more time on it so you can see what I'm talking about. Is everybody good with that? Anybody have any questions about any of that? Because that's a lot. I get it. Okay. So we talked about how to find the new forms in well, actually, I just showed you how to find standard forms. So we did that. Let me see. What else did I miss anything? So when you click on these links, these links will open one great big Office 365 shared folder. So if you want the red line version, this is where you're going to do that. Everybody remember how we got there? We went Transaction Center, we clicked on Standard Forms, and then from there, it took us to Forms Revisions and New Form Releases, and then we clicked on December 2023, and then there they are, okay? All right, questions about any of that? Seeing none? let's move forward. Okay, Anna's here. They keep coming in. That's good. A little late, but all right. All right. So that being said, let me take us now to back to the PowerPoint really quick to catch up with myself. So that was the Standard Forms website location. Always be sure to use the current forms. And the way you can tell, use the current ones until the new ones are officially published. Don't, oops, more people coming in, admit all. Okay. It's not working. Karen, help. It's not admitting them, but I don't know why not. Okay. All right. So please don't use the red line version of things. They make interesting reading, but you know, I have all of these, by the way. I got them all for 20, 30 years. So just let me know if you want them. But the week of 12/18, it's 12/18, 12/19, roughly thereabouts. Okay. When the new revised forms are published, right, be sure to use those new and revised forms with new transactions. Okay. So again, if you've got a template going on, then make sure you apply that template to new transactions. Okay. Don't change forms in the middle of the transaction unless, you know, we send you a message that says you really need to be using the new one. We've had some rare situations where, like, for example, the FERPTA changed on the first of a year, and we had already published the forms, and so we weren't aware what the changes were going to be, and so they did come out, and then we went ahead and told everybody, you know, make sure you use the new FERPTA in your transaction. It's a very rare thing. All right. Okay. Do not replace forms in an active transaction. Just leave it alone. It's okay. And then again, always check with your broker. Okay. All right. CAR will not change or add forms to a transaction that you have in progress. And let's see here. If you've created templates, CAR will update your templates with the revised forms. They will not add a new form. The library will always be current. Okay, so let's take a look at the library. Well, we just did that. We took a look at the library, and then take a look at my webinar on how to create DRE compliant templates. I've got that webinar loaded up onto the YouTube website. So it goes through some of the little things that you need to make sure. Remember, the Department of Real Estate says that your signature line in your MLS and your signature line in your Zip Forms program must be DRE compliant. Okay, and so the big thing is, you know, make sure your DRE numbers are in there, your broker's DRE numbers are, and make sure that you have a reference to the company that you're with. You must always do that, and that's also an NAR Code of Ethics requirement. Okay, so queue up the QR code reader. So if you want to use your QR code reader to pull up that website, there it is for you. Not seeing anybody go to the microphone. I'm going to go ahead and move forward. Okay. All right. Always double check the revision date, top and bottom of the form that you're using. And now let's talk about new forms. Okay. So let's do that. Here we go. Drum roll. We've got a new form coming out. When I show you, you're going to go, wow, that's weird. So here's the new form. This is the only new form that is coming out. Okay. That doesn't mean, you know, it's a letdown. It's not like anticlimactic, but it's the buyer homeowners insurance advisory. And so remember, in the old days, and I like to refer to them as the old days, in the old days, getting insurance was not a contingency of the transaction. It's only been within the last couple of years that we've added insurance as a contingency. But when the buyer removes the investigation contingency, they are also removing the insurance contingency. So my advice to everybody is that my non-legal advice, again, is when you put a transaction together, that you have the buyer get a hold of their insurance company right away, and make sure, A, that they can even get insurance on the property, and then also find out how much that binder is going to cost. Get that binder over to the escrow company to hold on to, so that they've got that binder. They've got a quote, essentially. You want to make sure that they do that, folks, because things happen, things change. And remember, there's two things that appear on the Clue database. One of them is people, and the other is property. So remember that, you know, somebody may have had had a whole lot of water-related claims, and it may be difficult for them to get insurance, or the property that they're buying may have had water-related claims, and it may be difficult for them to get insurance. Ultimately, they'll get insurance, but they may end up paying a premium that they're not prepared to pay, which may also, by the way, prohibit them from getting the loan. So you need to get that buyer needs to get that taken care of early in the deal, and not, please don't wait. I mean, invariably in the old way that people used to do things, we wouldn't even see that buyer's insurance show up until right before closing. And it was usually one of those, oops, I forgot. And then, of course, at that point, you're just kind of sitting on pins and needles, hoping that things don't go really bad. Okay, so good form. I like it. It's the only brand new form. So again, this will show up in the library. It will not show up in your template, because remember, there's no such current form. This is new. Okay, so it will not show up in your template. So Linda's on the call here today. She knows that I will be adding this to the template. Okay, so importance of obtaining property insurance and purchase contract terms. These are going to make good reading. I'm not going to spend a whole lot of time on this, but I think we're all aware, hopefully we're all aware, that California has some real problems with insurance right now. It's a constant, insurance companies moving out. I personally think they move back. It's just, a question of trying to regroup, I think. But paragraph number 3 discusses that market. And I know some of the big carriers stopped writing policies recently. And again, my feeling is they'll be back, but are they going to be back at the time of your transaction? Insurance conditions, again, in red font, means that this was one of the last changes that they made. There won't be any other changes to the forms until they're released next week, and then you'll get the full-on change. So this is as close as we're going to get to those forms. But again, they wrote draft across it for a reason. There's some resources out there. I always love it when CAR does this. They put the website in here, where to go to. And your client, sadly, your client signs off on these things most of the times, right? Would we all agree? Most of the times without even reading it. And I think that's kind of dangerous. And this is why, we always say that your job is to advise and counsel. So make sure that you are going over this with your client about how important it is for them to have insurance. This is not something that you want to wait until the last minute. Okay. Notice that only the buyer signs it. There's no place for the brokers to sign it or everything like that. That makes it personal to the buyer's agent, the buyer's broker. So just be aware. And that's my only new form that is out there. Okay. All right. So let's take a look. Going back over here, that was the new forms. There's only one, and that was the buyer homeowners insurance advisory. And that's going to be CAR forms BHIA. I don't know why there's that little space in there. Okay, let's now talk about the revised forms. So I want to get into that. We're going to have to handle this a little bit differently, because there is a lot of revised forms. And where are they? Here they are. So let's talk about the revised forms, and without you having to see too much of my work product over here, I'm going to close that over. Here are the new forms. And so we're gonna tackle these in alphabetical order, but these are the revised forms. And I probably should tell you too. Let's take a look just for a second. The other subject matters are going to be. So this is the revised. This is the revised forms down here. But then we're also going to talk about the new and revised short-term vacation rental forms, something that CAR had gotten out of doing. So I'm going to save that kind of for last if you're doing short-term vacation rentals. I remember I was on the original 30 years ago. I was on the committee that created the short-term occupancy agreement, which was that vacation rental agreement. And so, here we are, we've morphed into this. And one of the reasons that they pulled these out of the library was originally because partially was to protect us, when we were doing short-term rentals, and then owners weren't paying the TOTs, right? They weren't paying the transit occupancy taxes. And so, we ended up getting into that mess. And so That's why they've created the new form. So we'll take a look at those. I think they're pretty good to have. And then finally, we'll talk about the new business forms. So if you're doing biz ops, as we call them, we've got a whole bunch of forms for that. So let's go into our revised forms, and there's a little arrow there, but that's not going to do anything. And so what I want to do is tackle these one at a time. It'll take way too long to open all these. So I'm going to just, let me see, can I do these just from the screen? Excuse me, goodness gracious, where's he? A sneeze on the truth. So anyway, bless me. So you know what, I am going to try to open, let's go ahead and open this up. So we've got our AOAA form, and so I'm going to have to go to a new share. This is what I was trying to avoid, but here we go. So our assignment of agreement addendum. So I think if you've been to my previous webinars, you know that I always say that contracts are freely assignable at law. That's just the way the law works, right? In commercial, we do it all the time. We assign contracts, we do all that kind of stuff. Well, probably about 10, 15 years ago, the residential real estate community discovered that that was a possibility as well. So because they're freely assignable, all kinds of things were happening. It was like the wild, wild west. And so what we did was we created some limitations on what you could do contractually. Legally, yeah, you can do it, but we wanted to create some limitations contractually. And so that's why we created the assignment of agreement addendum. Okay. And so here's and as you know, in your purchase agreement, there's a paragraph number 3K talks about the assignment, how much time the buyer has to notify the seller of an intent to assign a contract. And so now we've updated that. And again, this is the draft. Most of this has already been preordained. But so for those people who think that it's a simple process, it is not a simple process. I was talking to a broker the other day who was not aware of the fact that there's such a thing as a partial assignment versus a total assignment. So, I know we add the spouse, that kind of thing. We add a spouse to a contract. Well, that's going to be an assignment, right? And so once a contract is underway, we need the other party's approval to amend the contract, to create that agreement that is binding on all the parties, right? So and we have people coming in, we have people going out, we have all kinds of stuff happening. And this form does, I think, a pretty good job of addressing that. So I'm not going to go over each aspect of the form, but I am going to go down here and point out to you the red line part of this, and that is the consideration for the assignment. We added a part that says buyer has not received and will not receive any monetary consideration. Part of that was in response to, again, CAR changes their forms in response to legislation and to litigation. And so part of that was, buyers were saying, no, we haven't received anything, any monetary consideration for the assignment. And then once they put that in writing, then two days later, they do. And so we said, not only have you not received it, but you will not receive it. So, and if you're going to receive it, then you need to notify the seller contractually about that. Okay. So it's usually the buyer who does the assignment. Interesting thing of note, when we take listings, we actually pull the grant deed on the property. And so we actually have a listing that we were taking where it turns out that when we pulled the grant deed, we thought there were two sellers because that's what showed up in CRS tax and that's what showed up in RPR, but there was actually a third seller on title. So folks, make sure you're being very thorough, because remember, when you take a listing and you put it into the multiple listing service, the rule in the MLS is that you have all of the necessary signatures, which means that, in this situation where there was that third seller that didn't show up on the more common reports, Linda, who is of course an amazing broker, she's the one who always looks up the grant deed to make sure she's got just everybody. And there was that third person. And by the way, the third person, the only difference, same exact name as one of the other two, but the middle initial was different. And so Linda caught that. And so folks, please make sure, because remember, if we hadn't had that third person on the listing agreement and somebody brought in an offer, that third person could say, I'm not going to sell, and you need me to sell the property. And so as the seller's broker, I might end up having to pay a commission for a transaction that really never finishes. Is everybody okay with that? So that's my little aside. So a little bit of contract law, a little bit of MLS rules, things like that. So let's go. In fact, can I do this without having you switch? Maybe not. I'm going to pull up the bill of sale, which I don't think is going to be incredibly interesting to most people. Again, some of the stuff we're going to go through pretty quickly, but this is the bill of sale with or without a warranty. Some of you may, you're going to find this more in your commercial. You're really not going to find it in residential. You might find it on residential income property, but this is actually a whole new form. I don't think we had this before, and so they've made some corrections along the way as they've been creating the form, and there you go. That's the bill of sale. Let me see. So now I've discovered that I can go back in and grab my CL form, which is my commercial lease agreement. And so if you're doing commercial leases, interestingly enough, we are hanging on to the word landlord, even though we decided in the residential field to change that to the RPO, right? The rental property owner. Again, if you're doing leases, I assure you commercial leases are very different than residential leases, but we seem to be hanging on to that landlord, and most of that is just changing the name that was in there before. So we call the landlord the lessor and the tenant is the lessee. So it looks like they've gone back to landlord and tenant in the agreement, probably because they're trying to write things in plain English. So that everybody can understand it. Again, remember, the contract may not be enforceable if it's not understood by the party that signed it. And so there's a lot of legal principles behind that. So again, before you start telling people that, make sure you check with your broker, make sure you check with your attorney. Accessibility standards, obviously, new laws in the commercial arena for things. Arbitration of disputes. Again, a lot of this is just landlord changes to the name landlord. Okay, so let's take a look at the commercial confidentiality and non-disclosure agreement. And that will be the CML CNDA form. So you have one already, the non-disclosure agreement. It's more prevalent to be used in commercial settings, where the owner of the property does not want the terms that they were willing to agree to leaked out. And so again, it says right here, not for use with 1 to 4 residential properties. Okay, let me check our participants, make sure nobody's waiting. Nope, we're good. Okay. All right. So I'm not going to go through all of that. If you're doing commercial, again, I will send all this to you, make it easy for you. And then on the heels of that one, I've also got my commercial environmental issues addendum. I don't think we need to go into site inspections and environmental surveys versus environmental reports, things like that. But again, this is the addendum for that. Next one we're going to have, and I shouldn't overshoot my target here because we may need this time, but again, if I got to let you out early, I'm okay with it. So again, please ask questions. Here is the commercial landlord's environmental consent. Complete only if leased property involved in a transaction. Let's pull up the last one relative to that. And then I think, Alice, I think I have a form for you here coming up. So commercial release agreement, again, buyers conducted an investigation, et cetera, et cetera, et cetera. Following items, everybody has agreed that they're going to cancel the agreement, that they're going to do a credit run, whatever, kind of the equivalent of a request for repairs kind of form. So let's take a look at the next one, which you are more, and by the way, that's commercial now, okay, please. So don't try to use that in a residential setting. I think a couple of people have called me on the commercial purchase agreement and joint escrow instructions. And so folks, if you've got a residential template going and you've got all the form fields filled out the way that you like to fill them out, and you're about to do a commercial transaction, then I'm going to tell you, if you add the commercial form, it should be populated with the information from your residential transaction, but definitely proof your document. But notice how similar this is to the purchase agreement, the regular purchase agreement. Okay, so it should be the same. But again, we've got our grid and financing gets pretty crazy there. So what other changes are we going to see in there? Let's see if I can find them pretty quickly. So here under security deposits and unearned rent, because the chances are good that you're assuming a tenant, so to speak. So there's our provision in paragraph number 14. And then I believe that was, I think I've got one more big change coming in here. Let me see if I can find it. Again, if you're noticing that arbitration is in there, remember we left the arbitration agreements in the purchase contracts, but not in the employment agreements between the broker and the client. So that's it for that one. For those of you that happen to notice that, then we have, and now I'm wishing I had separated the revised forms into the tenant forms as well. Notice a change in terms of tenancy, and so this tends to be your instruction page. All right, but this is a form that we've had for a while. You're going to remove this instruction page before serving the attached 2-page form. Okay, I've had people that send the entire thing, and there you just gave up your explanation to you of how to do that. Note to tenant: once this notice of change in terms of tenancy has been delivered to you pursuant to paragraph 5, the specified change to your tenancy will take effect on the date identified before paragraph number 1, even if you do not sign. So in other words, it's coming to a theater near you. Prepare for it. Okay. All right. Questions about any of that so far? I want to make sure we're opening up a lot of forms here. Okay, I think you're going to see more and more short sales. So we have a bankruptcy attorney who works in our office as a broker, and he says he is seeing a lot more defaulted properties. In fact, we're putting one on the market probably today or tomorrow. But again, we're seeing more and more of these. So if you haven't worked short sales before, then short sales are coming again to a theater near you. And there's always that scenario where the seller has not delivered short sale lender's written consent in a timely manner. So we updated a form for that. Again, notice my dates up here, 12/23. Make sure you're using the current form. And so this is cancellation based on failure to deliver short sale lender consent. In other words, the lender had not done that yet. It was interesting having the conversation with him this morning because the rules have always been in place, recently been in place that the lender cannot dual track, so they can't pursue the foreclosure at the same time they're working with you on the short sale. So again, check with counsel on that. Make sure you're hiring qualified people. Down here, amendment of the agreement, because the short sale lender's consent requires changes to the agreement. So this would give you the opportunity to change some of the terms of your agreement. Okay. All right. And again, you're going to start seeing more of these. It's just coming to a theater near you. Employee estoppel certificate. I suspect most of us are probably not going to use this form, but once the commencement of employment, things like that, chances are pretty good you're not going to use it. It is in the library. And again, if you're having trouble finding these things, I will send you the red line version, and it's going to be the last of them. It's also included in my newsletter. If you're getting my newsletter, underneath the classes that I was teaching, oh God, am I going to have another newsletter? I will probably have one more newsletter just to wish everybody the happy holidays, but there won't be any classes for me for SDAR this year. There are going to be other classes for me that I am doing through separate avenues here. So if you're getting the newsletter, you'll have access to that. If you're not getting the newsletter, you won't know. But anyway, all the forms, it's a button. You click on the button, all the forms pop up. Okay, because I created that so that you'd have access to that. This is a good form, the HID form. Why you need a home inspection. Be an informed buyer. By the way, we're dealing with the lawsuits today from buyers who waived inspection contingencies and then never did the buyer's investigation of the property. You don't ever want to get in front of a buyer doing that. You want the buyer to investigate the property, even in scenarios that I've been in where the agent said, you got to remove the contingencies, the seller's agent, you got to remove the contingencies up front. I counsel my buyer not to do that. But even if they do remove the inspection contingencies, they can still do the inspection. So I want to make that really, really clear. I didn't see the top. Whoops, sorry. This is FHA, required for FHA transaction. Yes, thank you for putting that in there. Sherry's here. Let's admit Sherry. Holly, thank you for that message. But as I was saying, if you do not want to prevent the buyer from doing their inspection contingency of the property, even if they don't have the contingency anymore, you still need to give them the right. They have a right by law to investigate the property, and if you interfere with that right, what we're seeing today is, I would have. Found out all these bad things that are wrong with the property if I had done an investigation, and oh, by the way, the seller did not disclose those things in their disclosures. And so if you take a look at your Avid form, the bottom of page 3, it says right in the Avid that the seller's duty of disclosure and the agent's duties of inspection do not replace the buyer's obligation to do their own investigation of the property. So again, I would not interfere with the buyer doing that. So what's included in the inspection, et cetera, et cetera. How to find the inspector. Appraisals are not home inspections, very clearly. Now, some people are confused because on my FHA and on my VA, the appraisers tend to think of themselves as little mini inspectors, but they're not there to do the rigorous investigation of the property that the buyer has to do. So the buyer would want to hire a group, preferably with errors and omissions insurance, preferably who are certified to do those a member of a certifying agency. So for example, CREA or ASHI or something along that line, to make sure that they have those inspections done by a qualified individual. And so I always tell everybody I am not that professional, so I'm not going to do it. Remember, your job is to do a reasonably competent, diligent visual inspection of the accessible areas of the property. The investigator actually investigates properties. So, and that's the buyer's duty. Okay. Radon gas, other health issues. Here's a phone number. I'm surprised they don't have the website in here, but there's a website as well. Questions about that form? Holly, thanks for asking. No questions about that. Let me pull up the ICA, which is the new independent contractor agreement. The revised, sorry. So the revised independent contractor agreement, remember, the Department of Real Estate requires that you have a contract between yourself and your broker, okay, that outlines the terms of your relationship. And the contracts have waffled back and forth between binding and non-binding arbitration. But this is where the broker sets about what they expect you to do. And then we've got our Exhibit A and our Exhibit B down at the bottom. Exhibit A, of course, your broker tells you how much they expect you to charge for listing agreements and other agreements for services, so other employment agreements, and that's between you and your broker, not to be discussed outside of your brokerage. Okay, and then Exhibit B discusses what compensation you're going to get. As a result of what essentially A looks like. Okay, so your broker must set a minimum standard. So, and if you go below that standard, you need to be discussing that with your broker, whatever that standard is. I had a conversation with somebody earlier in between our break today about the MLS rules. So the MLSs have pretty much across the country have all dropped their minimum listing from $1 to $0, because even $1 is a minimum. I don't think we could argue that you can go below 0, although sometimes we feel like we're working below 0, right? Paragraph number 15, we've got our pro stand materials. I'm proud to be on that committee again next year. Let's see here. Linda, said, I think even Corey said, how do you find time to do all this? And I said, I have a thing called a calendar. And so I keep track of everything that I'm supposed to be doing on a thing called a calendar. So here's my binding arbitration, et cetera, et cetera. Much, much more complicated than it was, when I got into real estate, and our purchase agreement was only 1 page. So that's the big change in there. So be aware. Let's take a look at my LBSB, which is my loan broker. I'm not going to spend a lot of time on this one. If you're doing loans, if you're a loan broker, sales broker disclosure, this is the form for you to use. Let's see, my MARS Mortgage Assistance Relief Services became a very popular topic back during the loan modification times. Remember that even if you are working a short sale, you need special credentials in order to be able to negotiate the loan. So you can negotiate the sale of the property that may be short, but you're not there to renegotiate the loan. And that was a very common mistake. I remember when the Department of Justice issued their rule on it, and they indicted 16 attorneys the day that they initiated it. So be really careful. Talk with your broker. You can do short sales, but make sure that you are not going outside of that lane, as Wayne Bell, our former commissioner, would say. Okay, so be aware of that. That's the so the next one is the short sale negotiation notice, and again, same kind of language is included in there. Let's see here, and then we have my MHDA. So we're going to get out of short sales now. Let's talk about my manufactured home dealer addendum for use only when cooperating with a manufactured home dealer. And so remember, that's a separate license. You can do manufactured homes, but manufactured home dealers are people that are selling the new manufactured home. Different licensing required, and you have to have essentially what they refer to as a dealer's license. So pretty significant form. I don't know if any of you are doing this, but again, I'm not going to spend an incredible amount of time on it. Red lines, versions of things. And again, the sad truth of it is that at the end, before we're getting to the these forms being released, some of these were really brand new forms that didn't have didn't have any revisions, but there were a couple of revisions made right before we got to this point. And so that's what's showing up on your screen. So that being said, let's take a look at our MMS, which, again, I don't want to spend too much time on mortgage loan disclosure statement substitute. With any kind of luck, you don't have any idea what that is. Then we have our office management agreement. There was this push for a period of time where, whoever was the office manager could create a contract between themselves and the broker for the company. I don't know. I kind of thought that it increased our liability. I know that, that not everybody does them. Let's just say that. But this is an agreement between the broker and the manager. So the OMA form is currently in existence and currently being used. But again, a couple little red line items in there that have been changed. Like the manager's real estate license shall be kept current. I think that's a pretty good idea, right? You have to have a real estate license. And by the way, they don't have to have a broker's license, so they can be a salesperson. And again, we have the two check boxes up here for that. What else? Anything else in there exciting? Alice, do you see anything? Revision? Oops, there's deductions authorized by or required by law will be withheld, et cetera, et cetera. And then employment eligibility. So as a condition of employment, individuals must submit acceptable documentation to the broker verifying their employment eligibility. I think they should probably add language about, the current California law. Okay, so we covered that one. That's my OMA form. And Holly, thank you for that reminder that essentially the OMA form, where did I go here? Back to my, where am I? Shoot, now I got to find it again. Okay, so I should go back up to the top of the forms so that everybody can see what they say. All right. Let's go to the next form, which is going to be my personal assistant contract. So, some of us hire people to come work with us. I have to tell you, my best year, I made $2.2 million in real estate. And I can tell you that the serious money was because I had 3 full-time assistants. And so a lot of people are reluctant to hire assistants. But I think it's the part that says I'm just too busy to do the minutia myself. And I had 3 full-time assistants, and they were good. And I was overpaying them. I felt like I was underpaying them, but they were very good at what they did. So remember, if you're going to have an assistant, whether licensed or not, you need to have the personal assistant contract. I think you should have your attorney draft it, but you may have something separate. Remember that your assistant may not act as an agent if they have a real estate license. And so unless they are hired also as an agent. So SDAR and NAR and CAR are going to look at whether or not the assistant does licensed activities. So if they have a real estate license, they can still be an assistant and not do licensed activities. We call that a LIFRO, or a license for referral only. But a lot of times we find that they're really, they're answering phone calls about properties and things like that, and they're doing things that qualify as being an agent rather than an assistant, and that we just believe that they're really just trying to dodge the paying of the board dues. Okay, so be aware of that. Also remember that depending on how you're paying your personal assistant, there may be some some tax withholding and things like that. So here, do they or do they not have a license? Are they an employer-employee relationship? Probably, right? Because otherwise they're an agent, right? It's the only other alternative. What are their duties going to be? What is their compensation going to be? And by the way, if you're paying them hourly, or you're paying them, whatever you're paying them is probably going to be subject to deducting, right? And so you'll need to make sure that you know how to do all that. Okay. Questions about any of that? Advances, future compensation, et cetera, et cetera. I think that's the big part of that. But again, I can't emphasize enough. Again, remember, if you hire an assistant, then you're going to have to also feed them. And I say that because you're going to end up, having to make enough money to also pay for them. And so I'm aware of an agent in San Diego who is doing 822 transactions a year, 7 full-time assistants. So I think it'll take you into a new dimension if you are hiring people to help you do those kinds of things. Let's take a look at our PMA form. And again, I'm doing these in alphabetical order, so some of them, are all, I'm jumping around on topics, but property management agreement. And I want to emphasize up here at the top, this form is not binding on the broker unless signed by a broker or office manager on the broker's behalf. So it has to be signed on behalf of the broker. So the salesperson will not be signing this. This has to be office manager or a broker authorized to sign on behalf of the broker. Okay, so we're back into our RPOs. Again, I'm going to need to share this form with some of the property management companies that I'm working with. But look, if you look at it, folks, look, it's really not that complicated. Look at the changes. There's no red line at all here. I mean, I'll have to go through it for sure to make sure that, this isn't like the 5th iteration of it. But under tax and withholding, RPO, that's the rental property owner, completes and transmits to the property manager, 1, if the RPO is not a California resident or a corporation or LLC qualified to conduct business in California, the Form 589, or FTB, Franchise Tax Board Form 588. Or if the RPO is a California resident or corporation, et cetera, et cetera, et cetera, then the FTB Form 590. Lots of paperwork in property management, probably of note. So we are a California corporation. Our company is incorporated in the state of California. We have brokerages that we own in other states. Hence my travel, brokerages that we operate in other states. In California, they are considered a domestic corporation because we are domestic to California. In other states where we're operating brokerages, we are considered a foreign corporation. So we're subject to the rules of that. And by the way, there are licensed as real estate corporations in those other states as well. So I learned the benefits of tax deductibility when you had offices in several states. Okay, so that's my PMA form, my property management agreement. I really like that form. I quote it frequently. Let's take a look at my RA, and I'm almost sadly disappointed that they're going to change the RA. So the RA, if you remember the Realtor Acknowledgement Form, they're right now, it's on the agenda. They are going to add this, so hopefully everybody's listening to this, but they're going to add this to the standard template that you have. So when you go to write your offer, this is supposed to be the first form there. The Professional Standards Committee moved it forward. Not to say that I was the most vocal person on the committee, but I just felt very strongly that we ought to be telling everybody the difference between a realtor and a licensee. And so the part that I'm disappointed about is the fact that we no longer have page 1, which said that it's a violation of Business and Professions Code 10177 if you call yourself a member of a party that or of I hate to say a club. What's the word I'm looking for here? That you have a membership in an organization that you really don't have. So if you're calling yourself a realtor, 437,000 licensees in the state of California, but only roughly 185,000 of those are realtors, which means they subscribe to the written code of ethics from the National Association of Realtors. So this is one of my best closers, folks. I always sign this, the very first form I signed in front of the client. And again, here's all the governing documents and the code of ethics and all of that. And so down here is where the individual realtor will sign it with all of their information in here. I kind of thought they should also have their brokerage's numbers, but all right. And then good news for us, local association of realtors, whatever that is. And then down here, the party, whoever we're presenting this to we now have a signature line for the party to also sign it. I'm not sure I agree with that 100%, other than the fact that it proves that we delivered it to them. I would rather exchange this for that big page 1 that says it's a violation of law to call yourself a realtor when you aren't. So watch for this form. They have promised me that it will be included on all of the offers and listings. It'll be supposed to be the first form prior to the agency disclosure form, where you actually disclose that you are a realtor rather than just a licensee. Everybody good with that? Be aware it's coming. I love the form. I've been teaching it for at least a decade. When did we come out with that? That was originally, we came out with that. I'll never forget. It was 2006. June of 2006, we came out with that form. Let's take a look at our REO advisory forms. Just really quick, oh boy, looking at the time. Okay, so we're okay. We might actually get out of here a couple minutes early. So my REO advisory, I'm taking a listing on a property being sold by a lender after foreclosure. Now, there are agents that are here in San Diego that specialize in this. The ones that intend to specialize in this when the market shifts in that direction, which it is, are the ones that are going to be, really reaping the benefit of it. I'm working with a brokerage firm right now that they're buying foreclosure properties from banks. So this would not be that, because this is not owned by so they are not buying properties that they are now going to own the properties and own the listings on the property, so they will not be subject to this form. But this is the form you use when you're working with a bank that owns the property, that took the property back in foreclosure. So again, I won't get into the Supreme Court holdings about dominion and control and things like that, but this is where the bank is reselling a property where they're really just reselling something that they had paper on. They didn't have any administrative control over any of the activities that were at the property. And so lead-based paint, the seller is not exempt from the federal obligation to disclose lead-based paints. Carbon monoxide, the sale is not exempt from so a lot of times real estate agents think that the bank is exempt from all these things. This is really good because this is going to go through, hazard zones. Seller is not exempt from applicable statutory obligations to disclose, earthquake, fire, or flood zones, right? So this will be good educational stuff for us whenever we're taking that kind of listing, that in fact, they are not exempt from all of those things. I have a number of transactions I've done recently where the seller claimed that they were TDS exempt, for example. Remember that if they are legally, in fact, TDS exempt, then remember they still must disclose, the exempt seller disclosure, which they can either use that form or they can use the SPQ, which has that information on the first page blocked in there. But the sad truth of it is that the decision as to whether or not a seller is TDS exempt is really a legal one. So, but I have a lot of people that, and I start asking them questions and start drilling down into it, and they get very frustrated with me. But I believe strongly that those sellers were not TDS exempt. And so, one of the brokers even told me that of course they're TDS exempt. They signed the form. It's okay, all right. So I just keep asking for the disclosures, and they keep denying me, and then all those emails go into the file to help me defend myself against my own buyer. So, so remember, it's the buyer who sues. Buyer finds out later. Remember, you are never exempt. Okay, you are held to a different civil code. You're held to Civil Code 2079. The seller could be exempt, but again, that's going to be a legal decision. Okay, all right. So let's take a look at my RGM, and this one is my radon gas and mold notice and release agreement, and again, U.S. Department of HUD. So purchasers are notified and understand that radon gas and some molds have the potential to cause serious health problems. By the way, the radon gas, while it's not as common in California as it is on the East Coast, it is the #2 cause of lung cancer, second only to cigarette smoking. So be aware, it's a serious issue. The good news is, in most cases, all you got to do is open the windows. But a lot of our houses now are so environmentally compact that creates a problem. I always tell you that mold is not. It is clearly a 4-letter word. It is not a word in your vocabulary. And usually, whenever I ask someone whether it's mold or mildew, they go, "What's the difference?" And then they realize they probably shouldn't be telling people that it's mold when, in fact, they're not qualified to make that decision. So again, purchasers are, here we are in bold print, encouraged to obtain services of a qualified, experienced professional to conduct inspections and tests, et cetera, et cetera. So good form. I'm glad we came out with it, and it mirrors essentially the statute. So that being said, let's take a look at my lease agreement. One of my favorite things. We do a lot of leases. So this is my RLMM. Let me see here the changes. Let's pull up my red line version of changes. There we go. So there's my paragraph number 11G, my periodic pest control. So the housing provider, so the rental agency or the tenant shall pay for periodic pest control. And then how much it is and all that. And then these other red things are just because we had to realign the paragraphs. Was that? Nope, that's not it. So there we go. So under insurance, and I get this question a lot, liability policy shall name the housing provider and property manager if applicable, and then et cetera, et cetera, et cetera. So they kind of spelled out what had been implied before. I'm glad they did that. I have a situation right now where the tenant moved in prior to providing proof of insurance. And then, of course, now it's a fight, right? Try to get that proof of insurance from them. So, contractually, they're out of contract. But again, that's going to be, I always kick it. My favorite term right here, qualified California, should say real estate attorney. So the QCREA, that was a term adopted by the attorneys at CAR, and I kind of like that. A qualified California real estate attorney. I'll get phone calls from people that say my attorney said, and then I'll go, really? And I say, well, that's interesting because I actually teach that to attorneys. And so, where is your attorney? Well, they're in Illinois. And so I always ask them, I say, did you tell them you were asking them a California question? Because they can be disbarred for that, right? Because they're not a California barred attorney. And so they're going to be very careful about not giving advice outside of Illinois. Okay, so city, county, or other local requirements. And again, San Diego, just so you're aware, and if you don't have a copy of it, San Diego has their own rent control ordinance, and they issue a tenant guide, a tenant protection guide, as opposed to the Tenant Protection Act. So the act is the state version of it. San Diego has the local version of it. If you haven't seen that, the law requires that on leases that were put together after, I think it was June the 23rd, you have to give the tenant a copy of that guide. So it tells the tenant all their rights, well, not all of them, but a lot of their rights and things like that. If you don't have a copy of it and you need a copy of it, send me an email, ask me specifically for that. Please don't send me an email that says, send me all your forms, because that's not included in these forms. But just be aware there is a tenant protection guide in San Diego that applies to San Diego properties. And so probably good reading if you're doing leases in San Diego. Okay. All right. Good. That's what we need there. Let's kick it over here to my RR form. I like the RR form. It just doesn't say what people think it says. It's fascinating to me. So here's my recitals up here at the top. That comes over from all the other forms. You got your buyer's request. Seller has no obligation to respond to the buyer request. A no response is a response too. We always say that. That means no usually. Where are my changes? Here we go. So I get down here into the seller's response. And so if there's a partial response, the seller only agrees to the following, check all that apply. And so it used to say seller agrees to all the buyer's requests except, but then it says also the seller can agree to a credit, seller agree to modify the price, and then here's what the price is going to be, so there won't be any confusion. So some pretty good changes to that form, and nothing down here at the bottom, although I would expect a change to the RRRR form. Aha, I was right. Here you go, my RRRR. And so here we go, seller only agrees to the following. So remember, this is in response to the request for repair form. And so remember, if the buyer doesn't agree to this part, they've got to submit a new request. So only agrees to the following, and there's that same language from the previous form. But then down here under seller's conditions, so seller's agreement only applies if the buyer removes the contingency, except the following, by signing and coming to an agreement on this RR, or removes those contingencies identified on the signed CR form. So I'm usually pretty good about making sure that I've got the buyer agreeing to remove the contingencies that the seller is expecting them to remove at the time that they agree to the credit or the price reduction or whatever it is that they agree to. Okay. All right. Let's take a look at my salesperson-owned fictitious business name agreement. And so I know I've had this conversation with a lot of people about, what you got to do. If you're going to, do not advertise yourself as an entity unless it's approved by the Department of Real Estate. But in this case, we have a form for this. So salesperson, broker, associate agree as follows. And then we just changed a whole bunch of numbers here. Broker authorizes salesperson, broker, associate to deliver to the Department of Real Estate. So remember, a salesperson can operate under a fictitious business name as well. And I see this commonly in a lot of states where I teach. So an application, the 247, signed by the broker requesting DRE's approval to use the county approved SOFBN, which shall be identified with the broker's DRE license number. Again, even if you have a fictitious business name, you must still identify your association with your brokerage firm. Okay, so essentially salesperson, we just added broker associate. If you are a broker working for a broker, you are considered a broker associate, which actually brought California in line with a lot of what other states were doing. Some states, by the way, don't even have salesperson's licenses. They only have broker licenses. Utah is an example. There is no salesperson's license, only the broker's license. Okay, everybody good then? By signing below, you agree, you understand what you actually signed. Now here we are signing things saying that we actually understood what we read. Let's hope that we actually read it. Okay. All right. Next, let's take a look at my SP form. This is my single party compensation agreement. So remember, I may be working with a seller who, is a for sale by owner, for example, and I would like to get compensated. I have to have, remember, you may not be compensated without having a written agreement to do that. And so in a situation where you were writing an offer on a property that was a for sale by owner, you are not entitled to compensation, whether from the seller or from your buyer. I would recommend that you have the buyer representation agreement so that at least you get compensation from your buyer. But this would be the situation where we would ask the seller to compensate us, kind of similar to that SPVB form, right? The seller's payment to buyer's broker. So, and again, we've added a lot of leasing language in here so that we can get paid on that as well. This is a copy out of the our LA, the listing agreement. And then we have our disclosure paragraph now, and then our representation. So broker will act as agent for principal exclusively in any resulting transaction, or broker will act as dual agent representing both principal and other party in any resulting transaction. And so again, principal understands, agrees that the dual agent may not, without the express consent of the respective party, disclose to the other confidential information. This is stuff that you hopefully are already know about. Paragraph number D, We talk about confirmation, so we're going to confirm agency. And then paragraph number E talks about our dual agency or our possible representation of more than one buyer or seller. Folks, that PRBS form is the form that we have in California, at least. We have the party sign. Oops, Linda's back. We have the party sign that authorizes us to be a dual agent to receive commissions from both. Okay, so remember that form was designed to protect you. It came from a lawsuit where the seller actually was a seller had listed a property and with a brokerage, and then an agent from that same brokerage, completely different part of town, but under the same broker's license, listed the property across the street for less money. And seller number one sued and said, you lowered the value of my property by virtue of the of your listing the competing property, and that's what this form is intended to keep from happening. There we go. Sorry. Temporary break. Okay. In fact, I don't know where I'm on this. Oh, there I am. I'm up there. Okay. So what else? Termination of agency relationship. Principal acknowledges, agrees that the representation duties of and agency relationship with the broker terminate at the expiration of the agreement, or the fruition of the agreement would be the other part of that. Here's my mediation provision, something that they've expounded on here, similar as we've seen before. Notice paragraph number 5, by the way, the attorney's fees is kind of a hangover from the old attorney's fees provision that says that the prevailing principal or broker shall be entitled to reasonable attorney's fees. Most of our contracts are getting away from that and getting into each to pay their own attorney's fees. And that is intended by CAR to try to discourage litigation, additional mediation. So these are paragraphs that come from those other agreements, additional mediation terms, obviously small claims court, you really can't hold them accountable for anything, unlawful detainers, things like that. And then finally, paragraph number 8, like where's that been, right? Management approval. So remember that the Department of Real Estate allows the broker to disapprove of the agreement or the terms, but they've got 5 days to do that. So folks, if you're not giving your paperwork to your broker until the day before closing, which, again, I was management, they'd walk into my office, they go, this is closing, and I'd go, when? And they say, Friday, and I go, Friday, when did you open this? And they say, oh, it was about a month ago. Well, I'm way past my 5 days, right? So so just be aware that the DRE requires you as either an associate, broker associate, or a salesperson to get your paperwork to your broker within 3 days. That's the DRE's requirement, giving the broker 2 more days to actually look at it and decide if they want to even take it. And then finally, your contract with your broker may allow for less time. So Linda's contract with her agents is 1 day, so they have to do it right away, and they share everything by the cloud, what is it, Dropbox or Google Drive and stuff. Okay, and then we've got our non-natural person as the seller. So a natural person, obviously somebody you prick them, they bleed. That's the natural person. A non-natural person is everybody else. So legally, anybody who's signing on behalf of another is going to be that entity seller. And in this case, could also be the owner of the property, the renter, the landlord. I'm sorry, rental property owner. So entity principals. And so this is something you should be familiar with your current purchase agreements and listing agreements. Okay, and that's my single party compensation agreement. And thank you again to Holly for reminding me to show you what form we were talking about. We get into my SPQ, and I love my SPQ, right? Because why? Because the TDS doesn't do it, right? And so the only person with a real estate license that I'm aware of that's in the legislative body is Brian Jones. And he's making quite a name for himself right now. But the legislative body doesn't understand, what we go through. So the TDS came out of the Easton lawsuit, which was an appellate court holding in 1984, but it did not cover all of the things that are actually, need to be covered. So when we look at the SPQ, this is CAR's attempt to add in some of the items that were statutorily required but left out of the TDS. So, for example, death on the property in the last 3 years. death of an occupant of the property upon the property. So that's California Civil Code 1710.2, and that says you must disclose the death within 3 years, as well as note to seller the manner of death may be material to the buyer and shall be disclosed, except for death by HIV or AIDS. So when I say I don't have to tell you, then you know what it was. I worry about this when I think about things like Heaven's Gate and the Sharon Tate murders, you know, and essentially it falls under the legal classification of a heinous act. So do you need to continue to make those disclosures after 3 years? I believe you do. But methamphetamine contamination orders, release of illegal controlled stuff, these are all statutory disclosures, whether it's adjacent to an industrial zone, whether including airports, whether the property is affected by a nuisance created by an industrial zone. So I think a lot of us would agree that Point Loma is an example, gets some airplane noise, whether it's located within a mile of a former federal or state ordinance. Notice there's no I in there. They fix that for me. I send them an email. When I see stuff like that, I just send them an email and they fix it. So in general, an area once used for military training. So Tierra Santa for sure, Coronado for sure, the Strand, right? Still finding stuff that goes boom, whether the property is a condominium. So again, I shouldn't have gotten off on that, but that was me doing my little disclosure class. So under 8, whether any structure on the property is an ADU. So now here we go. We got the ADU stuff coming. If yes to D, then has the ADU received a permit, et cetera, et cetera, et cetera. Now we're starting to see what I always suspected, which is where they're going to start taxing the ADUs. So of course, you know, it's all about revenue, right? So let's see here. Anything else? I think that was the hot button. Here we go. Paragraph number 18, whether the property was originally constructed as a manufactured or mobile home. Okay. So that's my SPQ. A good one to have. Obviously, I recommend very strongly that you know that you have the SPQ in every transaction as part of your contract. Let's take a look at my SPRP briefly. SPRP is just, and I think, frankly, if you're representing a seller, I think you should have this in every transaction that you do. I never see it, but our listing agreement with our seller says that they are going to have to find another property. We don't want them to be homeless. We don't want them to be committed to closing the transaction with a buyer when they may not be able to close the transaction that they are buying. And so paragraph number 1, we've added seller shall deliver to the buyer at the time of removal proof of replacement property, either a contract for purchase, an escrow number for that purpose, or a signed lease or rental agreement. So now we're looking for proof that they've done that. And then under C for the replacement property, and then down here, cancellation of replacement property. So if the seller's replacement property is in or enters escrow, or there is another agreement and either part of that escrow agreement gives the other notice of cancellation, seller shall within 2 days here deliver to the buyer written notice of cancellation. In other words, they missed out on the opportunity to buy the house they wanted to buy. Paragraph number 5B, again, we got to talk about our notices to seller to perform. So after first giving the seller an NSP, a notice to seller to perform, if the seller fails to give proof of replacement, okay, this is talking about the buyer's right to cancel. And then again, D is covering what we talked about above, seller gives notice to seller of either party's cancellation of the agreement for the replacement property, and that gets everybody essentially off of the hook. So going back up here, sorry, I know I sound like I'm racing with a clock, and I am, but I do want to get all these done, and yeah, we're doing pretty good. I still think I can get you out of here early. My TCS, this is a new one, right? So this is my that didn't come up. Okay, hang on. Transaction cover sheet. Okay. We've added a couple things in there. Housing provider language. Those are going to be my big changes. Whoops. There's my mortgage type, FHA or USDA. Okay, and that's that form. And then my TEC, one of my favorite forms. This is my tenant estoppel certificate. And so we have created a bar graph for this one, which is kind of a good thing to do. The other one's kind of jumbled together. But again, this is signed by the tenant and the owner of the property. So, copy the rental agreement. So this is us doing grids again. Remember, lawyers think in terms of structure and outline. And so date of the agreement, all this stuff. My advice when you're taking a listing, if you've got a tenant in it, get this form completed at the time of listing or at the time that the tenant moves in. Make this a requirement that tenant complete this at the time of move in, because you're probably going to need it when you go to sell the property. Remember, you can sell the property subject to the tenant's lease, but it's going to be really hard to get a tenant to fill one of these things out if they're filling it out 5 months later and they know they're going to be displaced. So I would get this form signed immediately upon taking a tenant into a property, because you're going to be asked to provide it along with when the TOPA form comes in, you're going to be asked to provide this form. So you might as well get this form done, and you do it early in the game and you do it without the fight. So here's my TOPA again. Amazing form. Some of us remember paragraph 4 of the old PAA, the purchase agreement addendum. And that was how we addressed tenant occupied properties. But now, obviously, it's much more complicated today. So under paragraph number 1, if the seller is able to remove existing tenants prior to closing, seller shall disclose to the buyer when the property became vacant. Okay, there's a surprise. I'm seeing Donna Hayes's name on there. Donna, are you trying to get in? Oops, you're in there. Okay, all right. And then whether the tenant vacated voluntarily. Remember, we have places like in San Francisco where you really can't. You get rid of a tenant and you tell the tenant you're going to be moving back into the place, and you don't. Did you have to evict the tenant? What were the circumstances behind whether or not you paid them to leave, whether they filed a lawsuit, a UD essentially, and then the buyer is a tenant. So what do we do in the situation where the buyer is actually occupying the property? You would think that they would be less trouble, but not always. Security, seller shall transfer to the buyer tenant through escrow any unused deposits and all prepaid but unearned rents, if any, prorated as of close of escrow. That's that weird situation where you accept rents from a tenant. For example, they send you the January check and it's for January, February, March. Sometimes tenants just want to get that money out of their account. Alice, question. Are you giving me a high five or a question?
Yeah, no, I do have a question. So, but it's about this form and about the commercial purchase agreement I'm doing right
It's
now,
going to
but I
be
think
on
you have a lot
me.
of forms
How do I make it
going.
so I can hear you? Hang on a second, Alice. Don't go anywhere. Stay with me. So it is my Yeti. Okay, try it now, Alice.
Okay, can you hear me now?
Heard.
Can,
Still can't
can,
hear you.
oh
Okay,
no.
let's go back to, I'm gonna put you on here. So let me join with audio.
Progress.
There you go, Alice.
Okay, you can hear me now.
I sure can. Go right ahead.
Yeah, I have question about this TOPA forms. Maybe we can save it at for the end after you finish going through all the forms.
Okay. Yeah, let's do that.
Thank you.
You are absolutely welcome. Now I gotta figure out how to get rid of that echo. It's okay. Oh, I know where it is. It's over here. And I'm going to. And that's what I get for trying something different. I think I'm going to mute you, Alice. Nope, you're muted. It's me. Speakers. Phone audio. No, I didn't do it either.
I think you need to
Okay,
turn on
that
one of
should
the
do it. All right, there we
computers.
go. Got rid of it. Okay. All right. Thank you, Alice. Where are we? I'm gonna lower that window. Okay, so again, if you're doing leases, be careful about accepting advance rents from people. There are certain rules that apply to that. And for any unit not occupied by the buyer, all of the terms of the TOPA shall apply. And security deposits down here on E7's itemization of all lawful deductions made, et cetera, et cetera. So good form. I like the form. I'm glad we came out with it. But remember, one of the parts of it is where's my oh, that's interesting. Oh, there it is. Okay, so 3. So see right here, tenant estoppel certificate. You will have this box checked on every transaction that I do that has a tenant in it. So I want to have that TEC form done. Okay. Now, I don't want the tenant coming back later on to the buyer and saying I've got a, you know, a $12,000 deposit, not a $1,200 deposit, that kind of thing. Let's take a look at our broker associate licensee assistant agreement. And again, this is for situations where this is going to be for my 3-party agreement. Broker also does business as, so we tuned a couple of things up in here for you. Let me see here. Unfortunately, I don't see this form used a whole lot, but it should be. DRE guidelines for unlicensed assistants. And remember, CAR also has an equivalent form, each of them addressing different issues. So DRE is concerned about DRE. CAR is concerned about CAR. So I would have them signing off on all of these. If I've got a 3-party agreement, I'm going to have that broker office manual, policy manual, which, by the way, I don't see a lot of those. The DRE does come into your office looking for those. I create them for brokerages, and I just wouldn't be doing business without one because the DRE likes them. And so if the DRE likes them, I like them as well. So I have my broker, I have my associate licensee, and then I have the assistant signing off on all 3 of those. Let's go to my WCMD, which is, of course, my water conserving plumbing fixtures and carbon monoxide detector advisory. What are the changes that we made on that one? So some changes to statute up here, and then essentially our admonition that you are agreeing you're signing off on this. So this is also the carbon monoxide detector advisory. Remember that information is also included at the bottom of page 2 of your TDS. Okay, so you don't necessarily need the separate form if you're using the current TDS. And then we have our water heater statement of compliance. Again, as I just said a second ago, form to be used by sellers exempt from the TDS, because then obviously they won't have a TDS. So other than REOs, different deal, and can be provided in conjunction with the exempt seller disclosure. That's CAR form ESD. I'm surprised they didn't put that in there. Anyway, that's the purpose behind that form, but that's all that is the admonition up at the top. Okay, everybody okay with that? Rounding it out here, I've got my equivalent water heater and smoke alarm. Remember, it's not smoke detector, it's a carbon monoxide detector. It's a smoke alarm statement of compliance. And again, for use only for REO sales with ESD. So so TCs, please stop sending me this form. Again, I keep getting these forms and it's like, it's not required. It's in the TDS, you're not going to get it. So smoke alarm statement of compliance, et cetera, et cetera. Do they even reference the fact that it's in the TDS? I don't know that they do, but it's at the bottom of page 2 for those of you who are keeping score. Okay, so that is all of the revised forms. So I'm going to talk about the short-term rental agreements really quick, just to let you know that they're there, and then I'll touch on the business forms, and then I'm going to let everybody go. Okay, so my short-term rental agreement, and so what's the purpose behind this? So this is for an occupancy of 30 days or less, rather than less than 30 days, which is what the old form was, which was 29 or fewer days. Remember that the laws that affect short-term rental by definition being less than 30 days, are different than the laws that affect leases that are longer than that. We even had people who would do the short term and then keep amending it to add on additional terms. And essentially they were attempting to avoid the proper forms that they should have been using, like the lease form. Okay, so why? Because short-term rentals are usually covered by either innkeeper liability or host liability. I always use the example of the Inn LeBairs. If you're living in the LeBairs and you don't pay your rent for that night, they can drill the door, right? So that they can do that. And that's different than what you as a landlord can do with a tenant that's got another lease agreement. Or any questions on any of that? Really just my excuse to get a drink of water really quick. Okay, good. All right. So what are my changes? So for occupancies of more than 30 days, but not exceeding 90, now we're going to use the seasonal addendum. So great for those of us in Del Mar and Coronado and La Jolla doing those short-term leases. Okay, so here's my seasonal rental, and that's going to be the STRA. We're going to show you that one in just a second. Will be for more than 30 days. And then whatever, we're going to add additional names, and then we go through all this. I had a property actually in the LeBaires Ocean Windows myself, and so this was a very complicated little issue. Damage deposits, cleaning fees, and here's my TOTs. All right, so my local tax assessed on rent, and so the city of Del Mar, for example, does have TOTs. But I didn't know a lot of people that were actually paying it, and frankly, it's part of the condition of having a short-term rental property in Del Mar. It's just the way that it is. So, cancellation policy. What else? Damage deposit. Okay, because it's really not a security deposit as much as it is a damage deposit. A damage is for damages that you do. I can tell you from personal experience, I've had people do some serious damage to properties to the point of essentially committing a felony, right? I mean, they're being abusive to the property, et cetera, et cetera. So, let me see, what do I need to tell you about that as I look at my screen really fast here? So obviously within 21 days, California law, after they vacate the property, the owner or the occupant is entitled to an itemized statement of any damage deposit that was withheld. I would recommend you let them know ahead of time what you're going to take out, but they are entitled within 21 days notice of what was withheld, and then they get the balance back if there is any, and they have to have an itemized list. And so that's essentially consistent with what the law says. So if the damage deposit is held by the owner, occupant agrees not to hold the owner's representative liable for its return. So et cetera, et cetera. Cancellation policy. Yeah, we would have people lease a place 6 months in advance and then cancel the day before. So, we had to have a policy for how we were going to dispose of that. These are not terms that you would use in a regular lease agreement. So a little bit different. Okay. Unauthorized holding over, what we refer to as a tenant as sufferance. A tenant at will is a tenant who is in the property for a lawful purpose. A tenant at sufferance is essentially a person who's in the property for an unlawful purpose. They don't have a lease or whatever. They've stayed beyond their actual term. And then late checkouts on the departure date will be charged 50% of the holdover rate, whatever that rate is up here. Cleaning, we're going to charge cleaning, and that's usually not an optional thing. Whereas in a regular rental property, the tenant would be obligated to return the property essentially in broom clean condition, unless you have a term in the lease agreement that specifies otherwise. Our lease agreement says professionally cleaned, including windows and carpet. But then we also give them the property professionally cleaned with windows and carpet. And so we're going to look for receipts. So again, the default language says broom clean. The law says broom clean. But if we have a lease term that amends that or appends that, then that's going to hopefully take precedence. So that's what we do. Let's see here, animals. Unless otherwise provided in Civil Code 54.2, no animal on the premises. Remember that it's not going to be my service animals or my emotional support animals. I do have a really good Q&A from the state on that. If you're interested in that, again, send me an email that asks for that specifically. The latest ruling on that, no smoking. We just don't allow smoking anywhere in the world. So, and the property may be subject to a local non-smoking ordinance as well. So my LeBaires property, they had an ordinance against smoking in the property, and we had a rule against it inside as well. So I'm sorry to those people that smoke. No assignment or subletting, and there's my damage deposit again, and then entry code, because this is the way things are going, right? So for example, in my house, I don't have keys, and God only knows I don't know where the keys are. But my doors are all coded, but they're also electronically controlled from my phone. My daughter just bought a car that's controlled from her phone. It's just, welcome to the 90s, right? So and then all my agents are going to start calling. So entry code to following locks and doors, whatever those are, here they are. They have not been rekeyed or recoded or rekeyed. Frankly, I think they should be, just for everybody's safety and peace of mind. Occupant agrees to rent the property. So that's going to be That's going to be my, whoops, there we go, short-term rental agreement versus what we were calling the vacation rental agreement. And then let's take care of the form that was referenced in that. And that'll be my seasonal addendum to the short-term rental agreement. Again, if you're not doing this, I know I'm putting you to sleep, but again, occupancy of more than 30, but less than 90. And then this is going to talk about all that stuff. So different rules apply to that. Again, I still have damage deposits and things like that. So, be thinking about this, for, what kind of tenancy you're actually going to have. Additional disclosures, if any, including lead-based paint. Don't miss lead-based paint, folks. This is really, really important. So lead-based paint applies not only to sales, but also to leases and rentals. And the penalty on this can be significant. My last reading, I think it was $16,000 per offense. So be very well aware of the fact that lead-based paint is something you don't want to miss. And that's going to be pre-1978 properties. Okay. Subletting and assignment, just as a matter of course, we don't allow it on our forms in California. We have to say that, because if we don't say that, then you can assign and sublet, right? So we have to, kind of wrap that one up there. Okay, everybody good? Questions about any of that? I'm going to pop over here my last short-term rental form. I can't believe I'm going to get done right on time here, but or a little bit early. Short-term rental listing agreements. So we were talking about the agreements with the tenants. Now we're going to talk about the agreements with the owners. Occupancies of 30 days or less, or a seasonal rental, depending on what box you check, from 31 to 90 days, not binding on the broker unless signed by the broker or office manager on the broker's behalf. So again, this red print will not be there in the final version that is released next week. So, so we do like to have that here. Sorry, let me just, I think the old rule is if you just turn the phone off, you're probably going to be a lot better off. So the red line won't be there. So, again, we get in here to my property broker will not manage the property. That's the default, or it's an or statement. The broker will manage the property. And then here we have the PMA form. And then if the broker will manage the property, the management fee is or is not included in the compensation specified in paragraph number 4. Here's my listing terms, listing, rental periods and rates, because those are going to change. My Del Mar rental for off season was $2,200 a month, but during the season it was $22,000 for the 7 weeks. So I had some real big celebrities in there, really good people. I enjoyed them. But anyway, so we obviously have to state the terms, and then owner does or does not authorize the broker to adjust rates in order to lease or rent the premises. Terms of the occupancy are covered here. Let's see, anything specific I want to talk. Owners advise that permits may be required to rent or lease premises on a short-term basis. Not all communities allow short-term rentals, right? Is located within an HOA. CC&Rs may have restrictions on short-term rentals. So we got to make sure we talk to people about that. Not all, I know a lot of properties in downtown San Diego do not allow short-term rentals. So, you sure hate to sign a lease agreement with a tenant only to find out you're not allowed to do that. So, and some whole communities have done that now, where the leases have to be in excess of 30 or whatever. Let's see, broker will use the RLMM form down here on B3B. Items included in the rental, much like we have on the, which I like those in the RLM form, all fixtures and fittings that are attached. Owner will provide the broker an inventory of what those items are. I rent a lot of properties out that are fully furnished, and the owners of the properties really don't care. They don't want to give me a list. Okay, fine, but then somebody breaks the head off of the king, with the jade chess piece. And then all of a sudden everybody's having a heart attack. So, it's like, well, you didn't tell me it was important to you, and I wouldn't have left it there if you didn't want it to be safe. But, yes, people go in and they play golf with your chess set. So, broker within 10 days shall create for the owner's approval an inventory. I don't know if I would take that assumption of risk on that. I probably wouldn't. Spaces items. So I've had owners who have not allowed tenants to have access to the garage because they've got the 7 Series BMW in there. No offense to those of you who have a 7 Series BMW, but they wanted their car to have its own garage and they didn't want anybody in there. So I've had that happen. So items that are included in the rental versus items that are excluded from the rental, and then whatever other amenities. So sometimes your HOA will have a separate fee for the tenant to be able to use the HOA's facilities. And that's something that you need to make sure you don't want the tenant leasing the place only to find out they can't use the services there unless they pay an additional fee, because you're probably going to end up with that bill. Then we have a little breakdown of what utilities we're going to ask the tenant to pay, and then paragraph number 3B, in addition to the owner reserve dates. And so I'm experiencing that right now with a property that we have in, I call it Outer Limits. What's it called? Outer Banks in North Carolina. We have a property there where we reserve the property for certain times of the year. So on those reserve dates, we want to have the ability to be flexible on that. So that's what this all says. Welcome to California. Compensation. And one of my favorites, I just got an email before I signed on to this from an owner of a property. Says, "Oh my God, we found a new tenant. Yay." "Oh, really? You might have just defeated my listing agreement with you that said you would allow us to sell the property." So if without the broker's prior written consent, the premises are withdrawn from lease rental, are leased, rented, otherwise transferred, or made unmarketable by a voluntary act of the owner during the listing period or any extension thereof, owner agrees to pay the broker compensation. So, I'm going to take a look at our agreement, make sure we've got all that. And we're going to expect to be compensated because we put a lot of work into that property. And then some other stuff in here. Do I need to go through all this? Let me see here. Compensation on subsequent sale. Obviously, I would, if the tenant purchases the property, I would like to be compensated for that. You're going to probably need to have a separate listing agreement. And I think I mentioned it in the beginning, new law starts effective the first of the year that says that you can't withhold more than a month's worth of equivalent of a month's worth of rent as a security deposit. But also you may not have a listing agreement that's greater than 2 years. So those are some new laws that are coming out. For rentals of 30 days or less, the entire amount, et cetera, et cetera. So, I'll let you read through this if it's important. For late fee, non-refundable. Okay. So again, we want to be really careful about making any fee non-refundable. So we have the language in there for that. Return of the damage deposit. Once again, 21 days. That's just California law. Been that way for a long time. MLS, we're going to put things in there. We may not even put it in the MLS. We may have an SELM, security and insurance. We just tell the owner that we're not going to be responsible for the tenant's toys or frankly, for the owner's toys. What else? Ownership title, same kind of stuff you're used to in your regular agreements. Tax withholding. This is the one that always gets people. So owner authorizes broker to withhold and transmit to California's FTB 7% of the gross payments to the owner that exceed $1,500 by the broker in a calendar year, unless the owner completes and transmits to the broker. Again, if owner is not a California resident, then Form 589. If they are a California resident, then Form 590, withholding certificate. Brokers and owners' duties. I always like to make people write these out, because when you write these out, you really start to understand how much work you actually do in a real estate transaction that people should be very thankful for. And then brokers authorized to rent premises for more than 30 days, et cetera, et cetera. So I'll let you read all this. Again, these are big changes to the short-term rental listing agreement, which used to be the vacation rental listing agreement. So they made a whole bunch of changes. Obviously, they didn't want us using this until after they had put all these into place. So for purposes of time, I'm going to go ahead and speed through this. So as I said to you a minute ago, the CAR is heading in the direction of language that says owner broker shall be responsible for paying their own attorney's fees and costs. And again, that statement is intended to discourage litigation. Okay. So all my usual exclusions and preservations of actions, you can file a lawsuit, but only for the purposes of tolling the statute of limitations, so that you can then go to mediation first, and then either arbitration if you've used the separate arbitration form, or otherwise, since this is an employment agreement, we like court, right? I'm sorry, I like going to court. Brokers like going to court. But when we talk about the client, the buy sell, the lessor lessee, we want them to have the option of arbitrating. The sad truth of it is, and I had a conversation with an attorney earlier today on this, the sad truth of it is we tell them to initial it because there's a place to initial it, or because somebody told us that they should initial it 25 years ago. The fact is the laws have changed significantly. Check with your broker, make sure that it is in your client's best interest, and it's also following your broker's instruction that they want the parties to initial arbitration. Don't just force it on people. Legally authorized signers, same language you've seen before. My entity owners, same language you've seen before, and that pretty much wraps that up. Okay, so that's the last of the short-term rental agreements. And the last thing we're going to cover just really fast. I'm going to do this really quick, but I've got a couple of forms in here. If you're doing business, what we refer to as biz ops, so the business disclosure statement. So essentially like a mini SPQ. And then I've got my business listing agreement. So a handful of changes to that, mostly changes in terms, but then again, some documentation changes. Once again, down here, if you transfer an interest in the property to someone else, again, this is a business opportunity, something where you're selling a business, ownership of assets, et cetera, et cetera. Don't want to spend too much time on this. If you're doing biz ops, send me an email. I'll send all these to you. Okay, so I want you to have them. And then I have my BPA, which is my business purchase agreement. Sometimes when we sell a business, we're also selling real property with it. So sometimes like they're doing, they've got, they're growing crops or something on the property, but so they're selling the building, but they're also selling the business. And so that's why we want to differentiate between the two. Not an easy subject. There's the grid, but again, 15 pages. So it's right up there with our purchase agreement. So I'm not going to go through all of that because that would keep us here all night. And then my business purchase allocation of purchase price, where all the money is going towards things. And then finally, my business purchase furniture, fixtures, and equipment. And here we go for that. So yay, that's going to round it out for what we're trying to do as far as the new and revised forms are concerned. So we've talked about the new forms, we've talked about the revised forms. There are 38 revised forms, most of which you're not going to use. So don't worry about that. I think, frankly, if anybody here was keeping score, probably had about a half a dozen or slightly more forms that are actually being used. Seems like a lot. We tackled it by function: new forms, revised forms, then new revised business forms. Actually switch that around. The short-term vacation rental forms first. And I want to thank you for joining us. I think I very much appreciate the value of your time. So yeah, I am going to let you go a little bit early. I don't know what time it is. God, 3:51. A couple of things. If you want copies of the new and revised forms, there is a link included in my newsletter. So if you're getting the newsletter, you click on the link, it'll pull all the forms up for you. Okay. If you want to get to any of the videos, and so I have people invariably afterward saying, how do I get a copy of this video? You just go to the YouTube website. Here comes the QR code. So you take a picture of the QR code. Now it takes you right to the YouTube website. You can see all the videos. What I do is when I duplicate a topic matter, so like new and revised forms, so this is today versus the one I did in June, I will make the June one go private. And then this one will be the public form that you'll be able to see. Podcasts will be under a separate number. You can also type into your browser at Burke Real Estate Consultants, Inc. Case is important. You can also use the bit. I learned how to do all these things because nobody was doing them. And so, I realized that if I was going to do if I was going to be able to utilize those, I'd have to learn how to do them. So I learned how to do the bit.ly links. I learned how to do QR codes, so folks, I don't know what kind of application that would have for you in your real estate business, but it's good to have those things. Case is important. And then please remember, when you do go to the YouTube website, like and subscribe. Like just because it makes me feel good, but subscribe so that you are made current whenever there's an update. You would actually have the updated version you would be notified of that when you signed into YouTube. It doesn't send you emails and stuff. So just so you know that's there. And so that would also be a good place for you to see the podcasts I'm going to be doing and things like that. As I always say, if you could think of any other topical things, SDAR is committed to supporting you and your business. And so let education know, education@sdar.com. You can always copy me. You can send it to me, copy them. Just make sure that they're aware of the fact that you want these platforms. So let them know, education@sdar.com. And then, so thank you, Karen. Thank you. That's sweet. Thank you. It's funny. I can see it on a different, I've got two computers, so I can see that message in there. But yeah, SDR, listen, they rock, right? So they are committed to your success. So weekly emails that I send out are again, that, or if you just want to get a hold of me. So if you want to send me an email, if you got a question about something, now I did include the email address at the bottom of all of the slides. I've learned how to do that too, headers and footers, right? But I want to help, I really do. So I will not get in front of your broker. I want to make sure that you know, if you ask me a question that your broker really should be answering, I will tell you, you need to talk to your broker about that. But for most practitioner level things, I am more than happy to help. So let me know. Any questions, anybody? Otherwise, I'm going to call it a wrap. Questions?
I do have a
Seeing
question.
none. Alice, we will reconnect after I end the
Sounds good.
SDR version of this. And thank you all for being here. I very much appreciate the value of your time. I'll be back on Thursday. I've got 2 more webinars to do, and then I guess that's it. So we'll see what happens. So thank you all for being here today. And again, as always, I wish you the very, very best. As we say from my hometown of Del Mar, I look forward to seeing you around the track. Thank you, everybody. Take care for now. Bye-bye.